Good afternoon. It is 1 o'clock on Wednesday, May 14th, and I see that a quorum is present. So I'll call a meeting of the State Pension Review Board to order and ask that Ann do a roll call.
Chair Paul Braden.
Here.
Robert May.
Here.
Andrew Cable. Robert Massengill. Leslie Poole. Here. Keith Brainerd.
Here.
Wayne Roberts.
Here.
We've established quorum, so I'd move on to item 3. So discuss and consider board administration matters, including the following. The first is the approval of the February 26th board meeting. I'd entertain a motion to suspend the reading of the minutes.
So moved. Second.
Motion made and seconded. All those in favor?
Aye.
Any opposed? Motion carries. Okay, is there any discussion from the board or any corrections that need to be made to the minutes that were circulated? I didn't see any myself. Hearing none, I'd ask for a motion to approve the minutes.
So moved. Second.
Motion made by Mr. Roberts and seconded by Mr. Brainerd. All those in favor?
Aye.
Any opposed? None. Motion carries. And then we'd consider excusing the absence of board members from the February 26th board meeting. And I think that Ms. Leslie Greco-Poole, who has rejoined us, yay, was absent at the February 26th board meeting, so I would make a motion that her absence be excused.
So moved. Second.
Any discussion? All those in favor?
Aye.
Motion carries.
This rate we could be done in about 10 minutes.
Those are the easy things. Next item 4, is discuss and consider educational training program for trustees and administrators, including the following items. And I'll go ahead and read at least the first couple items. Item 4A, receive report of the April 15 working group meeting. 4B, receive report on the development of the proposed draft PRB rules, Chapter 607, relating to the Public Retirement System Minimum Education Training Program. And 4C is consider approval to publish the rules proposed in the Texas Administrative Code, Title 40, Part 17, Chapter 607, relating to the Public Retirement System Minimum Education Training Program in the Texas Register for comment. And then 4D is to receive an update on the development of PRB training. So with respect to item 4A, I think we're going to ask Michelle Cranes to give a report.
Good afternoon, Mr. Chairman and members. I'm Michelle Cranes with the PRB staff. At the last board meeting, the board asked the working group to consider a number of items, unresolved issues relating to the training program. And staff also reached out to a number of systems to gather their input and check in to make sure that we were thinking about these issues in a way that made sense for systems, since they'll be the ones who will ultimately have to implement these training requirements and comply with them. The working group met on April 15th, and there's a summary behind tab 2A, as well as the packet from the meeting. Staff has gone ahead and incorporated the working group's recommendations on these issues into the draft program rules that we're bringing to you today. So if it's okay, I thought I'd go over those working group recommendations as I walk through the rules. Thank you. First, a few words about the draft rules. So we've split the rules for the educational training program into 2 batches to match the deadlines in the legislation that established the program. So what we've brought you today is the first batch of rules that cover the minimum educational training requirements themselves, as well as rules for accreditation of educational sponsors, so that educational providers and potential ones out there can start and go ahead and start working and getting prepared to provide the training. As you'll recall, the legislation requires us to have the training requirements in place by September 1st, 2014. So that's why we've brought you these rules today. We'll then have a second batch for you in draft form at the August meeting that will address compliance to line up with the date in the legislation that doesn't allow us to even start tracking trustee and administrator compliance with the education requirements until January 1st of 2015. So rules related to how trustees and administrators will report their training hours to us, and how we'll track those and then report them to the legislature will be coming to you in August. So behind tab 2B, you'll find a summary style chart that outlines the main points included in the rules, and then the rules themselves are behind 2C, and that's what I'd plan to do, is to walk through those, point out areas that are working group recommendations as well as a staff recommendation, and answer any questions that you have. Ultimately, today, staff is requesting the board's authorization to post the draft rules for public comment in the Texas Register, of course with any modifications that the board may choose to make. So if it's okay, I'll walk through the rules behind tab C. Thank you. So the first two sections, and I should mention that our agency's counsel has taken a brief, very general look at the rules, but we'll do a more thorough review, and has asked us to mention that the numbering could change between now and when we post them, the numbers of the rules themselves. But as numbered currently, sections 101 and 103 lay out the authority and establish the authority, purpose, and definitions for the rules. The first substantive section, I would say, is 105, related to applicability of the training requirements. So you'll recall from the last board meeting, as staff looked at how to apply the training requirements to the universe of trustees and administrators, our research had found that the definition in the government code for trustee essentially covers three things: that trustees have the fiduciary responsibility for assets of the system, for overseeing investments and expenditures, and for the administration of benefits. Using that definition, most systems clearly have a governing board, and the trustees are easily identified. However, in some cases, primarily in the case of public retirement systems organized under Chapter 810 of the Government Code, we found that there were several possible layers of governance. So you have systems where there's a sponsoring entity board as well as several other boards in an oversight or administrative capacity. And what these rules in Section 105 do is acknowledge that for some of those systems, not all 2 or 3, for example, layers of governance should be subject to the training requirements. So we've crafted exemptions that we think will help the board apply the training requirements to the people who are actually holding the fiduciary duty and responsibility, and that make sense in a manner of speaking to take and be required to take the training. So what the rules here would do is exempt a sponsoring entity board that's only responsible for the creation, termination, and amendment of a public retirement system. Again, not those day-to-day duties or fiduciary responsibilities. And members of a committee that's appointed by the sponsoring entity to act in merely an advisory or oversight capacity. Again, not doing that day-to-day supervising or administration of benefits and assets. Moving on to Section 107, that's where we have sought to provide clarity on the definition of system administrator. So again, in most cases, it's quite clear via statute that a system administrator is the person designated by the board to supervise the day-to-day affairs of a system. But in reality, there are some systems out there, 810 plans, and especially some of the smaller local firefighter systems, where it's not as clear who's filling that role, or they might have someone that carries the title of administrator, but whose role is simply clerical, and doesn't meet that statutory definition of supervising the day-to-day affairs. So here, at the board's direction from the last meeting, we've put into the draft rules an exemption process whereby systems would certify to the board that they either have designated an outside entity to act as system administrator. In that case, we're talking about a third-party private company such as a bank, which would already be subject to state and federal requirements and not really under the PRB's purview. Or in the second example that I'd given earlier, they could certify that the person they have as administrator really is more of a clerical role, and that a trustee, oftentimes in the case of a local firefighter plan, the chairman himself, is performing the duties in statute of a system administrator, doing that day-to-day administration. So in either case, the system would certify to us through a certification letter that someone else will be responsible for taking the training, or that they've outsourced everything completely to a third party, and that's very rare, honestly. So that certification letter is something that we plan to bring to you in the future for your adoption. Moving on to section 110. This is really the meat of the draft rules here, where you find the educational training requirements themselves. As you'll remember, there is a first-year requirement for new trustees and administrators to complete 7 hours of training in the core content areas within their first year of service. And those core content areas include fiduciary matters, governance, ethics, investments, actuarial matters, benefits administration, and risk management. I'd like to draw your attention here to the highlighted text, which is an optional staff recommendation that we've brought for your consideration. And this comes from the realization that what the working group and board sought to do is require 7 hours in these 7 topic areas, and they established that a person must touch on all 7 areas to fulfill that core. However, as staff began drafting this, we realized that it might be useful to provide a tad more clarification or narrowing of that focus if the board should desire. So we came up with an option that would say that no less than half a credit hour and no more than 2 credit hours shall be earned in a single content area. And essentially what that would do, I think, is preempt the unlikely but possible scenario that someone takes 15 minutes or 5 minutes in an area and wants to consider that to have completed the intent of taking the core in each area.
I think that's good.
So you're saying that a participant would need to have at least a half an hour in each of these?
Exactly, and then at a minimum and at a maximum that they wouldn't be able to take more than 2 hours in a single area, and we think that might help prevent, the situation where someone took half an hour in each area and then had, I think, 3.5 hours left and took them all in one. Of course, you could go with the minimum only or the maximum only. We thought a min and max might make sense.
What it really prevents is somebody taking 7 hours in one single core and covering it all. So, you got 7 items. Ideally, you do an hour in each one, but you can't quite make that. So I think requiring at least half an hour in each one seems to work.
And members, just to point out that the board would have the flexibility if the members feel it's more appropriate to say an hour in each. I think the staff's thought was by setting a minimum of 30 minutes, it gives a little bit more flexibility to folks who would be getting training. But I think probably the first step is to decide if there's a minimum threshold within each category the board feels is appropriate. Is it 30 minutes or is it an hour? So the staff recommendation is trying to provide flexibility, yet still achieve the concept that every subject matter is covered for at least 30 minutes.
So would you like a motion for the optional staff recommendation here that you're describing?
Well, maybe we should go through it all.
Okay.
Because then if we have one that we don't agree with, we can cut it out but adopt the rest.
Sounds good.
Or if members would like to discuss and say we agree with the staff recommendation or direct staff on each particular item, and then the final motion would include incorporating those selections by the board on those items, or anything else that the members see that they would like staff to change before we move forward with the posting.
Okay. Does anybody have any objections to the proposed staff recommendation on this section?
I'm okay with it.
Everybody seems okay with it.
I have a question. I might be referring back to a previous meeting, so just kind of bear with me. But what is the training just going to be online and they're going to read it? I mean, because I thought it would be self-paced where they were automatically going to be spending an hour? Like we were already developing the training in that way.
The training could be from a variety of sources, including PRB online training, which we'll be discussing in a little bit, kind of where we're at with the development of that program. There's a variety of providers in the industry that offer training. So it could be in person or it could be online. And we do discuss later on in the rules how we credit in-person training, actual time spent in the course. So what we're focusing on with this, I think, is 30 minutes of real training. If you're online, the online courses that we're looking at developing, you would just complete the course, and the course itself would be at a minimum of 30 minutes. I think we've talked internally on staff, and we'll get to it a little bit more in depth, that we could, whatever we develop online and provide to the systems for those folks who would like to use our online training, would be able to at least meet that half hour. And in some cases, I think, could we do an hour in each subject may be appropriate. We may have several hours on certain subjects because they're in depth. I mean, as years down the road as this develops, but we wanted to make sure what we proposed in the rules that the PRB itself in its training program could deliver on. And so that's part of the thought process in this. But for in-person training, whether it's at TechSpurs and CPERS, all the other groups that do provide it, we have addressed how we will count credit hours and what that counts for later in the rules to make sure it's clear. We're talking about actual course time, not time that includes, for lack of a better word, breaks. And so we try to address that and be specific in that regard.
Okay, thank you.
Go ahead, Michelle.
Okay, thank you. Continuing in Section 110, the minimum training requirements, subsection B sets out the continuing education requirements. So this is after that first year of service, the trustee or administrator has taken their 7-hour core. They would then need to complete at least 4 credit hours of continuing education in either core or non-core content areas within each 2-year period from there on. The non-core content areas include compliance and risk control, legal and regulatory matters, pension accounting, custodial issues, plan administration, Texas Open Meetings Act, and Texas Public Information Act. And here we've included another recommendation for your consideration. This one comes from the working group, which states that a trustee or administrator shall not be subject to the continuing education requirements for any term of service that is less than 2 years. This essentially takes care of that logistical problem that we'd raised at previous meetings of a person, for example, who has an even numbered board term as a trustee and might have done their core in their first year, then gone to 2 hours of continuing education and has 1 year left. What happens, to the training requirement during that last year? The working group's recommendation for that, and other scenarios where someone might, for example, leave their term of service, for whatever reason. The working group's recommendation was to simply waive any time period that's less than the 2-year continuing education cycle that has been established, and that I think is probably the easiest way for both us as staff and the participants themselves to handle that. And then if the person was reappointed to another term of service, they would begin their continuing education 2-year cycle again at the beginning of their new term.
See, I understand the issue that's trying to be addressed, but I'm not sure the language gets you there. And maybe you can talk to our authority council. Because so if somebody serves a 2-year term, right? So it's a term of service. This is less than 2 years, but you're serving a 2-year term. The intent would be after the first year, you do 7 hours, and you don't have to do anything for the second year, right?
Correct.
But that's not what this says. Because though I'm serving a 2-year term, it's not a term of service less than 2 years. And then if I'm up again for another 2 years, does that count? You're supposed to count the full term, so that then I'm in my 3rd year of sitting on that board, I'd have to do my continuing education requirement, but the term of service is still only a 2-year term. So I think we need a little wordsmithing on this. I think I understand the idea, which I don't disagree with, but I think we need to massage the language a little.
And probably to the effect of term of service and no longer serving in that capacity on the board from that date thereafter.
Yeah.
Because clearly what you're talking about is somebody who's leaving the board, will not be serving on the board in that odd number year. That was the intent, and the board had asked the working group to look into this, and the working group recommendation was, in these cases where a member who's in their last year of service and is not going to be reappointed and will be leaving the board within 6 months or a year, that because the continuing education requirement is a 2-year time period to complete, if you're only on for 12 months of that 2 years, and you will no longer be a board member after that, that we would not apply that continuing education requirement in that cycle. And I think the language that we could include and work with our AG council and with the member, with the chairman and any other members to clarify is that.
I would suggest, that sounds fine. Let's do that approach, but then have it be Judge Cable and Paul, Chair Braden, sign off on the final language. Any other member that's interested in, but at least have those two to make sure that it complies with the discussion here and the thought of the committee.
Good approach.
I'm fine with that.
So, Mr. Chairman, to be sure I understand, what we're saying here is it would be for those with a term of less than 2 years and whose term is scheduled to expire.
Well,
Is that the case you're trying to get at?
but I'm not sure the less than 2 years applies, because what if somebody has a 2-year term? Well, it's not less than 2 years, unless you're saying the remaining term. I think the concept is, first of all, do people sit for terms of 2 years, or is it really more of a 3 to 5, 7?
Yeah, a 2-year term is very unusual. And I think some of the confusion may be happening from what staff meant when we wrote term of service was actual service,
As opposed to the appointed term.
as opposed to the appointed number of years. Yes, and that should be clarified.
I mean, I understand the concept, and I'm comfortable. I can work with the AG staff to make the language, but the idea is, if for you not to be required to do this if you're in essence last year of service. But you're saying there's really not any 2-year terms, so it's.
I can't say there aren't any, but I think it's much more common to have 3 or more.
Members, just to clarify, there are instances where, in particular with certain boards, and I'll point out with the ERS board, where a board member resigns due to personal, and another member is appointed to serve out 18 months, let's say, and maybe that member doesn't get reappointed. What we're trying to achieve, obviously, if you're on a board and you're going to be there for a minimum of 12 months, the core applies. Everything after that rolls to a 2-year cycle for continuing education. If you're on for 18 months, that last 6 months, to say you're not coming back, that's the members we're trying to capture with this exemption, is folks who will be going off the board, not reappointed. And we do address people who leave the board and come back within a time frame. That's later on. But these are for folks who would literally, their service with that board ends and they are no longer on the board. And I think we can tighten up that language to achieve that more clearly.
Yeah, I agree, because I mean, if they're really people who aren't routinely appointed to 2 years terms, it's really more an academic exercise than drafting or anything else. But.
And members, the kind of the discussion of the working group was, well, do you just apply 2 hours to that last, do you proportion it based on how many months or years they have? And so the working group recommendation was to say, well, if this person's literally going off the board, they will not be serving anymore, that this wouldn't apply. So I think we can work to clean that language up.
Yeah, I'm fine with that. Okay.
Okay. One more point I'd like to make under this section of the rules is that we've attempted to provide further guidance on the courses that may be taken in each content area in a document entitled Curriculum Guide for Minimum Educational Training, which is attached at the end of the rules in your packet. This is a draft that we've put together. We are hoping that this document will provide some guidance to both systems and sponsors as they begin considering training that they'll provide or looking at the training they're already providing. These are not intended to be hard and fast that you have to hit on every subtopic in each content area. And I'm sorry, I should probably hold this till we get to the document itself, but just to let you know that it's intended as a guide. This is a draft, and we will be bringing hopefully a finalized version to you in August, and I'll speak just a tiny bit more about that when we get there.
And members, in other rules that we've adopted, we adopt forms. This gives the board the flexibility by referencing it in the rules that if there are amendments to that policy document, we don't have to go directly into the rules and go through that process. And again, this is intended as kind of policy guidance. And you'll see it as referenced under this section 110 under subsection D, 2D, that adopts the curriculum guide for educational training. This is a discussion that came up at the working group, and I think we've worked with experts who provided some information on their training. Some of the statewide systems as well have provided us background on what does fiduciary training entail, and what we've looked at and worked through is trying to provide guidance to whether it's folks who are getting training in-house, boards of trustees that will provide training to their board members. What is the expectation of fiduciary training? So this is, again, intended as guidance. It's not intended to be necessarily the specific rule, and we will continue to draft this, work with folks interested in this. This is strictly a draft at this point in your board packet. We will continue to flesh this out as we come forward in August with these rules and public comments for the board to consider.
Okay.
Okay, section 111 sets out how the working group established the process the working group is recommending to handle the phasing in of current trustees and administrators, people who already will be serving when this program rolls out on January 1st, 2015. This section of the rules would expire in 2 years from that date on December 31st, 2016. The working group's recommendation to handle this was to allow current trustees and administrators 2 years from the program's start to either complete the 7-hour core or take process in a look-back process whereby they could apply for credit from the PRB for training already completed during the previous 2 years, essentially during 2013 and 2014. To receive that credit, they would submit an application form, which is again a form that we as staff will develop and bring to you for your adoption at a later date. So the idea here, I think, was to provide as much flexibility as possible, but stay within the intent of the legislation to ensure that trustees and administrators have a basic, baseline of knowledge to discharge their duties responsibly.
Any discussion on that? I thought that was a good compromise.
Okay. Section 113 lays out the process that Chris had mentioned a minute ago for applying the requirements to trustees who are reappointed or reelected to a subsequent term of service, or administrators who are rehired at a later date. So the working group recommendation here is to only require folks who are reappointed, reelected, or rehired to repeat the 7-hour core, that initial core requirement, if they've had a break in service of more than 2 years. If they haven't, if it's been less than 2 years or they're reappointed immediately, they would simply roll into another 2-year continuing education cycle.
Okay. Any questions on that provision? All right. Go ahead.
Okay. We're moving now into subchapter C. These are the rules that would apply to sponsors, educational providers. Again, as Chris had mentioned, those could be organizations, the PRB, or retirement systems providing their own in-house training. Section 120 lays out program standards that would apply to all of those providers, that are basic standards that we thought would provide some guidance and some structure for what training standards that training would have to meet to be acceptable to the PRB. Section 122 includes language guiding systems and sponsors on how to compute credit hours for training, be it online or in person. And then I would move to 124, which sets out a streamlined process for course approval for regular providers of education. So essentially, you might remember here, we had discussed in the previous board meeting, the goal here is to allow for a I think, streamlined process where those organizations that are regular providers that are, providing a lot of education to our trustees and administrators, to allow them to become accredited sponsors, and then after that application process, having achieved accreditation, not have to submit each and every course for individual course approval, to allow them some, efficiency gains, as well as for staff. The rules here would say that accredited sponsors could be accredited to offer the core content areas, non-core content areas, or both. So it would be possible for us to accredit a provider to provide only non-core, for example, if they didn't have offerings that met the standards that the board sets for the core. This section also outlines provisions that would allow us to audit and review the educational offerings of accredited sponsors, handle complaints, and then, if necessary, go through a process to revoke and possibly reinstate a provider that was found to not be meeting the board standards. There is a working group recommendation here that's highlighted, and that issue that was posed to the working group was how long should the period of accreditation for sponsors be, and their recommendation is that accredited sponsors would be reviewed after an initial first 2-year period, and then again after each subsequent 4-year period, or at other times as the board deems reasonable. But the idea here would be, of course, to do an initial review, make sure that things are looking good, and then come back every 4 years after that. And I should have mentioned earlier, but just a quick side note, staff had a lot of help and good guidance in drafting these rules from model rules that we'd referenced for y'all before from the State Bar and the Texas Board of Public Accountancy. So a lot of these things mirror provisions that we thought were best practices in their model rules. We didn't have to invent the wheel here.
What would, and maybe Chris answered this, what would you envision would be the renewal review process for an accredited sponsor?
I guess we're just beginning to look at that and would want to work with the members on that. I would expect part of it would be an examination of their history of providing training, and that's what I think when we look to other agencies that have continuing education requirements under state law. What we've seen typically involves, historically, have they been providing this type of training? How long, to what extent? Do they have certified programs whereby they issue a completion of a course as opposed to you just show up at a seminar? Those are the types of standards that we've seen applied at State Bar, public accountancy, and I think we would continue to mirror it for, again, not to reinvent the wheel, for other agencies that have similar requirements under law in the state in that regard.
And I guess there would be something to let the sponsor or the accredited sponsors know, when we check you every 2 years or every 4 years, we're going to be looking for these type of things.
Just a question, did we receive input from accredited sponsors, or not all possible conceivable ones, but any that we would anticipate being definitely on our list?
We haven't yet, but I would hope that we will once we post these for public comment, and I think it's a good point to make sure that we reach out and speak with.
If it's open to public comment, and they certainly could comment at that point. That would take care of it.
Sure.
My thought.
Okay. Any further discussion?
I'm just curious, we're covering a fairly wide track here. Are we expecting one provider to cover all of these, or do we expect 7 different providers, for example, with regard to the trustee and administrator training?
You mean within the core, the 7 core topic areas? Well, I believe, and I don't want to speak for Texpers, but in our discussions with them, they're modifying their trustee training program to cover all 7 areas. I believe that what we've seen from other statewide systems already cover all 7 areas. So the expectation for some, and there will be others who may only do part of that, would be that they would cover all of that. And that would be an option for either a sponsor or somebody who's just providing this training, that they would, again, folks who are providing training can also submit, if they are not a sponsor, for approval for that specific program. So we've tried to keep it flexible, and throughout the rules what we've also tried to do is draft it to give the board flexibility in cases where it makes sense to review a sponsor if something comes up, and again I think there's been discussion 10 years from now, there could be 30 different sponsors. The University of Texas, we've heard discussion. Other universities are going to develop their own trustee training programs. If something were to happen that gives the board the flexibility to say, we saw something in the news about the way you're doing training that gives us cause for concern, we'd like to take a look at this. But I think we've tried to keep it so someone could get accreditation for offering strictly risk management or investments, and we would be able to review that, and if they would like to apply to be an accredited sponsor, you don't have to teach the entire core. That was not the expectation.
Thank you.
Anything further? Okay, go ahead, Michelle.
Okay, thank you. Section 126 covers the obligations that would apply to accredited sponsors, including things such as record keeping, providing certificates of completion to participants in their training sessions, and conducting regular course evaluations. These, again, were modeled after some of the other agency rules for continuing education programs that we'd looked at, but we tried to just take the pieces that we thought were the most essential, and you'll find here another highlighted working group recommendation. This relates to record keeping, and the recommendation is that we would require any accredited sponsors to maintain records of participation, such as attendance lists and other documentation, the syllabus for the course, for a period of 5 years, subject to audit at any time by the board. And just to give you a little context, this issue was posed to the working group, both for sponsors and systems themselves. The system piece will come later during the draft rules on compliance, but the question essentially raised was, there are two possible ways we could go with supporting documentation, meaning we will have trustees and administrators or systems reporting their training hours to us. In addition, we could require them to send in their certificates of completion for every course that they took, or we could follow the example from some of these other agencies and just require them to maintain that documentation themselves, as they do in a lot of other cases where the system administrator would keep those certificates, and if there was ever a doubt or a question of whether someone attended a training, we could then request those documents. So requiring that of the sponsors, I think, acts as sort of a cross-check, in that hopefully unlikely scenario that we weren't sure if a trustee or administrator had completed training. The sponsor would also have the records of who was there that day to provide a cross-check.
Mr. Chairman,
Yes, sir.
is some of the answer to that going to be addressed in the second part of the compliance issue that you suggested earlier?
Yes, the requirements for systems themselves, compliance meaning what requirements will systems have to both take the training and keep the appropriate records that will show up there. Yes.
So if we're going to bring that part up later on, we don't necessarily have to satisfy that here. Do you agree with that?
Agreed, unless you have thoughts that you'd like to share now, we'd be welcome to hear them too.
Well, I don't want to create a bureaucracy, but I sure think it would be interesting to see, sort of in the aggregate, what kind of participation we're getting with regard to the program. It'd be interesting to see how many people are taking it, what are they taking. Doesn't have to go down to the level of individual trustees, but to know these were the courses that were offered, and this is what they chose to take, and this is what was taught, and this is how many people took it, and so on. I think it would be relevant and interesting.
And we will certainly know that by virtue of requiring the systems to report to us the training that their trustees and administrators took. And yes, when we bring compliance draft rules to you, you'll see in there that we will, I think our plans, and correct me, Chris, here, but are to require them to not only say, I did X training, but list the title, who it was provided by, and when and where, so that we have that information.
Yeah, and members, this deals specifically with, part of it is to have the sponsor accreditation process in place at this point, I think, to help with folks who may want to start working. I know some of the folks that we've worked with, so they can start adapting their programs and know what the process will be. Because the actual program doesn't roll out and tracking compliance till January, the idea of what we will be getting to the data that was discussed here, we will get that information because we will need the plans to submit to us, as Michelle mentioned, when they got their training, how many hours in what course. So we will have that information. We will need that information to be able to report back to the legislature and as well so that we can track completion, compliance. That just is the next phase of the rulemaking. This really only focuses on setting a requirement for the sponsor, essentially to keep paperwork. And again, I think we'll keep everything consistent. That was the discussion with the working group. But that certainly will be addressed, and we will absolutely need that information so that we can report back to the legislature that information.
Thank you.
Any other questions or comments on 126 recommendation? Okay.
Okay, section 128 pertains to accreditation of minimum educational training activities for non-accredited sponsors. This essentially is that the process for what we've been referring to in the past as those one-off courses, meaning if a trustee goes and takes a course from a provider who's not already a PRB accredited sponsor, or a sponsor themselves, let's say starts offering courses and wants to get one of their courses accredited versus going through the process to become a regular accredited sponsor because maybe they don't envision providing a lot of education, who knows. The idea is this is sort of a catch for individual courses. The process here would require sponsors or systems to submit requests for individual course approval to the board at least 30 days in advance of taking the course, with an exception. In certain exceptions, the board could consider something submitted less than that time frame, but the systems would be encouraged, if they're going to take something that's not already accredited, to get that in advance so that staff can review it and let them know whether it meets our PRB standards or not.
Could this be like industry conferences?
Sure, it could.
And I want to reiterate, as Michelle had mentioned, that we looked at other rules that are in place, and this seems to be the standard, this approach. I think with Board of Public Accountancy in particular, we've dealt with them in our seminars and conferences that we've provided, working through their sponsor accreditation process, and State Bar, that we've looked at these models and tried to fit those to the needs and the requirements under law. And again, we try to create some flexibility so that some trustee takes a training, they haven't gotten our prior approval, that it gives the board discretion if they want to apply after the fact. That is in there as well. What we're trying to do is give the board as much discretion as possible, and certainly as we move forward, and I think has been mentioned, getting the program out, there may be amendments to these rules going forward as we determine issues that arise. But what we've tried to craft is something broad that meets the requirements under statute, that gives the board and folks participating in this program flexibility, and then as issues arise, we can certainly address those as they come up.
Okay, good.
Okay, in the final section, 130, would deal with accreditation of in-house training activities, and this, of course, attempts to deal with the large amount of training that's already being provided by systems themselves or their hired consultants. Here, we would allow retirement systems to choose either track if they wanted to apply to become accredited sponsors and thereby have all of their training, approved and not have to submit individual courses. I would expect that's the route that, for example, the larger statewide systems might choose to take. Or they could apply for individual courses if, let's say, a system, just brought in their investment consultant to do an investments 101, then they could apply to us to have that count.
Any further discussion? Okay.
The final material in your packet behind the rules is that guide for curriculum that we'd already discussed. Again, just to summarize very briefly, the idea here coming out of questions from some of the systems of, what should be covered under governance, for example. Staff has worked to lay out some possible areas. This is not intended to mean that a course in governance must hit on all of these, but that it should be somewhere in the ballpark and give ideas and guidance. And again, this is a draft. We'll be bringing you a more final version in August.
Any questions on the curriculum guide for minimum education training? Attached to the back.
And members, I just wanted to clarify, part of the reason during the working group discussion, some of the discussion with the members of the systems themselves, members of the audience in attendance, was what's going to count, what's not going to count, and the thought process that grew out of that was developing a guidance document so folks understood what the intent of these core areas was. Because investments, for instance, could be a very broad discussion. And so we wanted to provide some guidance, whether it's for folks who may be designing their own program at a university or in the industry and wanting to tailor theirs for training in Texas, for folks who are doing training who may want to tailor it to what's going to be the standard in Texas. We needed to provide some guidance, and we'd like to thank the folks that have worked with us on that, because this is the product of a lot of folks providing input to the staff and us assimilating that into a draft document. And certainly any comments and something that we will continue to work on that members or the audience or folks out there have. But we did want to provide you an idea of what we have developed at this point, that there would be something along these lines that would go with the rules.
I thought this was a very thorough job. It looked a lot of hard work from the working group and the staff. Very well thought out and clearly well researched. So I commend all of you who worked on this so thoroughly.
I agree.
Agree.
Now, just to understand what we're talking about publishing, I think all the recommendations, both of the staff and the working group, the board indicated acceptance, except for a little wordsmithing associated with the recommendation in 110B3, which was that whole 2-year issue. Otherwise, I think what I'm about to add a motion for is the body of everything else, including the recommended language from the working group and the staff recommendation. With that said, I would entertain a motion to authorize the executive director to publish the rules after incorporating comments from the board proposed in Texas Administrative Code Title 40, Part 17, Chapter 607, relating to Public Retirement System Minimum Education Training Program in the Texas Register for public comment, pending final approval by the Assistant Attorney General and the board chair.
So moved.
Second.
I guess one amendment here, final approval by the Assistant Attorney General, the board chair, and Judge Cable, who chairs the working group.
So moved with that.
And second.
Motion made by Mr. Brainard, seconded by Mr. May. All those in favor?
Aye.
Any opposed? Motion carries. Thank you all on that.
And members, just, and I know we've mentioned this, and for folks in the audience and folks who may be watching online, we will be coming back in August with those comments. At that time, the board will review all the public comments received, and obviously staff will work. We will streamline that. We will work with the members of the working group and appropriate constituents. We will need to review those comments and make determinations on including those comments, amending the rules per those comments, or not, depending on the comments. At that point, the board can consider final approval of these rules. So it's a multi-step process doing public rules. This is just the first phase, and certainly staff will reach out to all systems to let them know. We will continue with this summary document. Hopefully the board found that helpful to make sure that's available. So folks who will be reviewing this, we've already gotten some inquiries for this information. We will make sure everybody gets a current copy, knows where to look at it, so that we've included all of our constituents in this process.
Good. So that really was items 4A through C. 4D said received update on development of PRB training. So anything you want to add on that?
Members, as
Thank you,
part
Michelle.
of the legislation, as well as the sunset recommendations from last session, is the directive for the Pension Review Board to develop a training program and to make that available online to the extent possible that we can. Over the last several months, staff have been working on evaluating how to fulfill that directive. Now that obviously we have a sense from what the core requirements will be, that minimum pension training. I did want to update the board, and we did discuss this briefly at the last board meeting, that we've been looking at what we would consider learning management systems, LMSs, as well as online delivery tools that are available and within our budget. Staff, we've identified a few cost-efficient options that are available. We're currently, for lack of a better word, demoing those. taking PowerPoint presentations that we've done at prior trainings, evaluating the software that's available for demo, looking at costs to make sure it's within our budget. And I think one of the discussions we've had that we want to make the board aware of is there are free options available, but in our initial gleam on some of them, they are very bare bones and I don't think provide necessarily the quality of education content that we may want. We're going to continue to explore it, and I will get to this in our budget discussion later. We do have some availability of budget within a reasonable range to possibly purchase software that would allow us to actually create better delivery. That we think because the PRB will be delivering training, we want to do it maybe not just putting a PowerPoint online, but actually having it so that we could do a voiceover or include a quiz, have some way of tracking that training that's more than just throwing some basic information out there. We think it's important to, as long as it's within our budget requirements and what we can afford, try to provide something that's high quality. And so that's really what we're trying to discern right now. There's really high quality products that are going to be beyond our range that we cannot afford at this point. But we think there are some softwares and products out there that are within our range that would be high enough quality that would meet our internal discussion standards, that we want something that someone doesn't go online and look at it and say, wow, this is not very good. Because we think it's important to deliver the best that we can within our budget. So we're at that point of evaluating that, and certainly if members have questions or want to know particular softwares that we're looking at, we can follow up with you on that. But we are in the process, in part because we need to have stuff available online. Ultimately, the goal would be to have all core content areas covered, that anybody could get 7 hours on our website. We're going to go step by step. First, we have to pick a software. Then the next step will be developing the content, posting it online. I would expect by January 1st we'll have covered some of these areas. I'm not sure if we can have 7 hours by January 1st, but within a reasonable time frame next year, we expect to have all 7 hours up there. And I did want to update the board on that, and it's another component of this program, and staff have been working hard on that, and certainly we will have more updates for you in August. And if any of the members have any suggestions, and also we probably will be reaching out to members to help put some of this content together, using your expertise, the fields that you draw from. So certainly we'd like to put that on your radar, that we may be reaching out to get some background. I know some of the members have presented at conferences in the past. We may be able to use those presentations. Certainly we'll want to work with you on that as well.
Good. Next item, item 5, discuss, consider study of the financial health of public retirement systems in the state as required by Section 7, House Bill 13, the 83rd Legislature, including the following items. 5A is receive report on the April 22, 2014 Actuarial Committee meeting. 5B is receive report on the May 2024 actuarial evaluations and PRB projected 30-year contribution shortfalls. And 5C is discuss recommendations on how a public retirement system may mitigate its risk of not meeting its long-term financial obligations. Bob, did you want to cover some of this, or are you going to have Chris?
Yes, I'll speak briefly and then pass this on to Chris Henson. We have had an interim actuarial committee meeting that a number of you attended, and the minutes of that meeting can be looked at and go into considerable depth, about 6 pages of information out of that actuarial committee meeting. So I certainly encourage you to take a look at what we said there. It's an ongoing process. We anticipate or plan to have our report ready by September 1, as the law requires. We'll go out for input to the various retirement systems, and our final report will then be submitted to the legislature by the end of the year. I'll turn this to Chris now to go through some of the tabs.
Members and audience, folks in the audience, there should be copies in the back if you haven't gotten it, of a short summary of the committee meeting with the key highlights, as well as the current draft minutes at the request of the members of the committee who had asked for that information to be provided to the members at this meeting. So members of the audience, this is in the back as well. to quickly outline, there was a presentation from staff. That report has been slightly amended per the comments of the committee members and the members of the audience where possible to reflect some of those suggestions. And some of those are the bullet points in your summary. Discussion about grouping systems by their governing statute. So that would be statewide systems, TELFRA systems, Texas Local Firefighter Retirement Act systems. Trying to, for lack of a better word, apples to apples comparisons on some of these data points. Also to footnote fiscal year ends when we discuss rates of return. So we've incorporated the comments at that committee meeting into a report that is the last item behind tab A. And if the members are amenable, I'll go through this report and kind of hit the highlights, and the committee members can certainly fill in their thoughts as we move forward. Really what we outlined, obviously the first part is the requirement to conduct this study. Again, this was a requirement of House Bill 13 last session. And the two outlined areas that are required to be in this study is to identify each system's ability to meet its long-term obligations and to make recommendations how any system may mitigate the risk of not meeting its long-term obligations. Those are spelled out in the language. What we've outlined, and this is reflective in the current amortization periods for our public retirement systems. There are 93 systems that are covered under this. So you can see the amortization periods, and behind tab B, and we'll get into it briefly, is the full report. This is a short summary. What we've put in and included is the total net assets of public retirement systems in the state going back prior to the 2008-2009 downturn. So you can see in 07, kind of at the height of the 2000 run-up, then the impact of the decline, and then the recovery that we've seen. And so that's outlined and shown in aggregate in the chart. And then what we've included, and we've worked with the committee members on this, staff have been reviewing and are going to review all 93 systems. We've gone through, at this point, the 42 systems that are covered that currently have amortization periods above 30 years. And what we've done is begun to look at the historical actuarial and financial information, contribution histories, plan design, and membership demographic information. And what we're looking at is the information that's been reported to the Pension Review Board over these years. And I'll briefly kind of walk through, we've broken out those different sections. And again, some of these comments from the committee members, we've incorporated their suggestions. But basically, the first chart under 1 shows you that in 2000, of the 28 systems, there's 28 systems that are currently over 40. There are 42 systems currently over 30. So there are 14 systems between 30 and 40. This chart focuses on those who are currently over 40. It shows what their funded ratios were in 2000, and then also currently what those funded ratios are. And I think what it reflects for those systems is a decline in their funded status. Obviously, we had 20 systems that have funded ratios over 80%. Currently, only 3 of those systems have funded ratios over 80%. So that was kind of the first step that staff began looking at, is that decline. We've also identified, since 2000, for these systems, for every dollar of accrued liability that has been that they have incurred, there's only been 44 cents of assets that have been gained. So that really speaks to kind of the divergence between the assets and the liabilities that has led to this underfunded situation. The second point, what we began to look at, was the return information that we've gotten. Some of it is internally calculated, and over the next several months, and we'll touch on in a future agenda item, there's the PRB 1000, the investment returns report. What we've broken out are those rates of return on a 1, 3, and 10-year basis for plans over 40 and plans over 30. You can see in the chart, as well as the standard deviations, gross and net. So those are the aggregate for all the plans in those groups. And then at the request of the committee and some discussion, we've broken those numbers out based on statewide, municipal, and as I mentioned, the TELFRA, Texas Local Firefighter Retirement Act, as you'll see footnoted on page 3 of 4. And so, again, one-year numbers in particular, different fiscal year ends. If your fiscal year ended in August versus December, depending on how the market was performing, you may see different numbers. Over a longer period of time, those calendar changes may not play as significant a role. I think one of the questions raised was, the statewide systems, ERS and TRS, which constitute a vast majority of the total assets, fiscal years ending August were not as impacted in 08 as folks who had their fiscal years end in December. However, their 09 numbers were a little bit worse. So again, we're trying to break this out so you kind of have an apples to apples comparison of the data that staff have been looking at and that we presented to the committee. So we kind of walk through those return informations, gross and net, based on plan type. And then lastly, under our financial history review is to look at what we call the non-investment cash flow. And what that is the contributions into the system less the benefits paid and expenses incurred. And we've looked at that over from 2000 to current and then also since 2007. And so that's where staff started for these 42 plans. And we presented some of this information to the committee. What we've seen on the whole kind of moves into the next part is one of the big issues that we've identified is for these systems in particular that have amortization periods over 30 or over 40 is insufficient contributions. And that's really outlined at the bottom there in the contribution history review. We've broken that out in part based on the Governmental Accounting Standards Board, GASB, at the time's ARC, was a 40-year arc up into 06, and then it went to a 30-year recommendation. I think they'd made that change or adopted it in 95 or 96, but they did a 10-year phase-in. And so the ARC amounts shifted from 40 years as a target to 30 years. And so we've broken those out. So we're analyzing those contributions based on that timing. And what you can see, obviously, for these systems is less than 100% on average contribution. And we've included that standard deviation. There are some systems, and I think we're aware of instances where a city may have put a lump sum amount in to try to make up a prior underfunding. And so in some years you will see an ARC payment that is well above 100%. In some cases, I think up to 400 or 500%. I think the City of Dallas did the pension obligation bond issuance in 2000, I believe 5 or 6, where they issued nearly $600 million in pension obligation bonds and deposited that into the system. Well, that obviously is a significant contribution over the ARC. So that those numbers are reflected in our analysis. Again, even with that in there, though, you see the tendency is lower than required contribution amounts over the long period. We've even gone to the last page here, and I'll get into this report. At the request of the committee, we've included the shortfall amounts, and originally we had the GASB shortfall amount, or the 30-year shortfall amount as we're calling it, where we looked at what is required to be at a 30-year amortization period versus what the system was actually getting. The committee asked if we could calculate those numbers for 25-year amortization periods as well as 40-year amortization periods for these systems. This chart just shows the average shortfall at those different rates. So for these systems that have amortization periods over 40 years, this is the percent of payroll on an annual basis they would need on average to achieve these amortization periods. And I'll show you the source data here shortly as we go through it. The last two items, we've also been looking at benefit plan provisions. I think there's been in the 90s there were some benefit decisions that were made in some cases for plans that had funded ratios over 100%, and we've been analyzing those decisions, tracking that. As well as demographic information. I think one of the big questions that has been raised has been, and particularly with the state system ERS, is the active to retired ratio, where years ago you had maybe 2 actives for every retired. Well, what we've seen with ERS is a movement towards a 1-to-1 ratio, and at the request of the committee we've broken this out by civilian and public safety, and the committee members can give a little bit more depth to that. But what we've seen for both types of systems is the active to retired ratio is declining. Not as significant perhaps in the public safety realm. The systems that we've looked at is getting close to 1-to-1 for the systems that we've reviewed. And certainly that plays a factor in your contribution cash flows going forward. And then lastly, we've provided, based on discussion at the last committee meeting and staff review, some preliminary analysis that we've seen. Obviously, the insufficient contribution levels, as outlined, have led to an erosion in the financial health of retirement systems. Over the last 10 years, we've seen varied investment performance. There are some systems that have done very well comparative to other systems. Obviously, over a long period of time, if you're assuming a certain rate of return and you're performing under that level, that will lead to an erosion of the financial health. For some systems, we've identified, non-investment cash flow may be leading to the deterioration of their health. And lastly, what we've identified for these 42 systems is that liabilities have grown significantly faster than plan assets since the year 2000. And that again is a preliminary look at the data for these 42 systems. And I'd be happy to answer any questions the members may have.
Any questions at this time?
Yeah, actually I do, and let me direct it to my esteemed panel member, Keith, and also you Bob. Since you all have quite a bit of experience in this, what in here is eye-opening to you, new?
Wayne, a number of things struck me. One thing I think is worth noting, well, first let me confirm, all of the data in here that we're looking at in this section titled Analysis of Historical Information, this just pertains to the 42 systems. Right?
That's correct.
The table on page 3 of 4, rates of return plan types, the differences in rates of return based on the plan type, to me, is striking. If you look at the net average return that varies between statewide systems, municipal systems, and TELFRA systems, is a striking difference. And the bottom line there, 10-year net returns, almost 7 for the statewide systems, 5.5 for the TELFRA systems. A huge difference in investment return, excuse me, and compounded over a decade, that can really make a substantial difference.
What I see in this as and just beyond just looking at these numbers, but from actuarial meetings discussing the problems of public sector defined benefit plans, core problem is not a full contribution, not following an actuarially recommended level of contribution, falling short of that, and for many systems consistently falling short of contributing what the actuary has recommended to that system. Also, high on my list is that we haven't really addressed here yet is volatility of employer contribution. It's hard for public sector plans for the employer to budget if there's a major shift from year to year at what the level of contribution is, and the need to try to smooth out that volatility, and various smoothing methods are being considered by actuaries. I'm not surprised, but I guess I was hoping for better. We've certainly seen an adverse trend in the funding condition of the systems over the last 10 to 15 years, and so those are a few key things that come out of that I think of.
I mean, a lot of this stuff gets reported in various trade periodicals and public policy magazine type things. And does this strike you as, I guess I'm looking for an affirmation here, but does this strike you as being better or worse than what's going on in the other 49 states?
Well, clearly not worse. Clearly, this is not a Detroit, it's not the state of Illinois, it's not the state of New Jersey, it's not municipalities in California in terms of really serious problems, even through a bankruptcy process going on with the city of Detroit. I think I would rate Texas above average. I haven't done any careful rating. We'll see what Keith thinks. We're not on the list of the ones with as a whole. We're not on the list of the worst cases in the nation. But we we've got to drill deep within our 93, and we do have some that are of real concern to me, and that work is ongoing, and I'm not ready to comment on it, on my thinking on it at this point. But so that's the way I see us. Probably above average, but we have some real concern areas too.
I would agree with what Bob said and add that in a lot of important ways, Texas structure for retirement systems is sort of a microcosm for the United States as a whole. You've got a handful of relatively large, very large statewide systems, most of which are in reasonably good shape, and you have a very large number of relatively small systems, and the condition of those small systems runs the gamut from very poorly funded to very well funded and everything in between. And with the exception of the ERS, the statewide systems are in pretty good shape. And then I would affirm what Bob said, that as a group, I think Texas is in far better shape than the nation as a whole, and far better shape than some states.
And it's tough to draw some really broad conclusions on aggregate data like this, but is this trend, I mean, obviously it's a concern, but does it warrant pressure to move away from defined benefit to defined contribution for a lot of the plans? I know it's going to, you know, when you're dealing with as many systems as this is, some are going to be yes or some are going to be no, but I'm looking at just a general overview of alarm.
I don't think it's suggesting that we should go to a defined contribution plan. We start with some inherent efficiencies within defined benefit plans. A large pool of money invested can be invested at a better gross return with more expertise than an individual managing his own money. A large pool of money, the expenses associated with the investment of a large pool of money, say $110 billion or whatever it is of teacher retirement, the expenses are very low, so it's a very efficient process of delivering benefits. Defined benefit plans are. I think that there's substantial evidence over the last few years around the country and in Texas that that systems are making changes. They need to make more, but they are making changes in the right direction. Those changes are a combination of reducing benefits, frequently for future hires only, but that good actuary, that counts. We're looking at this for the very long term. And they're looking at cutting benefits and increasing contributions on the employee side and the employer side. And I think that the action taken by the last session of the legislature for the Texas teachers, our largest system, is an example of how changes have been made that both increase contributions and reduce benefits, and it brought that system into, I believe it's a 31-year or thereabout amortization period, which is, it's certainly acceptable within our guidelines. No, I don't think so. There will be, this is a matter of opinion, and there are people who don't share my opinion and think that the only way that you can solve the problem is to, in effect, give up on the DB plan for the future. I don't think that's true. And I think we have evidence that even within the state of plans taking the actions that are strengthening the plans.
Wayne, the liabilities here are here, and even if we were to switch to a defined contribution plan tomorrow, these entities would still owe these liabilities, and so switching to a defined contribution plan would not do anything to address those. Really, what this comes down to is a commitment on the part of these plan sponsors to fund their plan, to not provide benefit enhancements unless they have a way to pay for them, and to make sure that they've got a plan and a policy in place to pay these down over the long term, because that's what they would have to do whether they switched to a defined contribution plan or not. That combined with what Bob said, and that is that certain models, namely pooling of assets and pooling the liabilities over a long time frame, is a much better model for everybody for providing a retirement plan.
An extreme on that pooling would be the Social Security system. Major pooling, creating a very large plan, it operates very efficiently. It's a very efficient way of delivering benefits to people from a given level of contributions.
It's not unusual to see a policy suggestion to an underfunded plan that, well, maybe we ought to just switch over to a defined contribution plan. But that doesn't really resolve the issue with the plan. And it's not so the issue. The challenge is not so much an issue of plan type. It's really about plan design. The way the plan is designed in order to meet what the employer is trying to accomplish and what the employee is trying to accomplish, and to recognize and accommodate taxpayers and their need to have some level of predictability and stability. Could some of these plans be reformed? Quite possibly. If they've got benefit structures that are unsustainable or too expensive, or other features that are not really meeting objectives, absolutely. But switching over to a defined contribution plan by itself is not really a meaningful solution.
The issue of, I call it strengthening of commitment of the employer to make the contribution to the plan is our big challenge for us, and we've got to, if we want to keep the DB plans viable for the long term, the employers and the employees need to step up or agree to some step down in benefit or a combination of the two. And we still have that going, and I have a particular concern about some of our larger independent local plans as needing to make some change. And we'll get into more detail on all the plans later. We do know that we're not, aggregates don't really work. They give a sort of a broad picture of what counts as each system and what it's doing, and that's we're drilling deep to try to understand that better.
Thank you, Bob. I think that's really some important topics being discussed. Chris, we sort of touched on some of these things, but do you want to cover anything additional under Agenda 5B, the reports on that?
Yeah, and just as we're talking about looking at specific plans, at the request of the committee, the staff have provided, and these are projections based on the most current information available to the PRB staff. Those shortfall amounts for systems with amortization periods over 30 years, and what we've outlined is the current unfunded, and as you walk across, you'll see in red the projected shortfall in dollars and in percentages of payroll for 30, for 25, and for 40-year funding. It's the last page behind tab B in your packets, members. And then, due to spacing, and staff has just not had time to get there yet, the recommendation is to also put this in perspective so that there is the sponsoring entity's general revenue or total budget, so that it provides some perspective of what the shortfall amount means to the total scope of the budget. Obviously, with the employees' retirement system being the most obvious, those numbers look extremely large, but in the scope of the entire state budget may not be as large a percent as maybe some of the smaller amounts. But this is our first pass, and certainly these are projected based on the most current information we have, and we'll continue to work with systems as we move forward. But this was trying to get a sense as to what systems would need to get themselves to these different amortization periods.
Mr. Chairman, may I ask a question, please?
Sure.
Chris, on this column, the as-of date that's immediately to the right of the column that's colored, do we expect, a lot of those dates there are 2012, some 2011. Do we expect to get updated information from any of those before this study is completed?
Yes, we do. We've been working with those systems. We also are likely to get updates from some of these systems, including the statewide systems, ERS, and those after the preliminary report comes out, but hopefully before the final report is due, because their fiscal year ends August 31st. We want to try to work with everybody to make our information as current as possible. We've been calling systems that haven't had evaluation done in a couple of years to see if one is on the way. So we are in touch, and we expect those numbers to update over the next couple of months.
It's been a good couple of years for investing, and getting more updated numbers probably helps some of those.
Okay. Chris, anything further on 5B?
No, that was the last item. Unless there's any other questions, I can move on quickly to the last item behind 5.5C. Again, one of the items, there are two main items the board was asked to look at is each system's ability to meet its long-term obligations, and then second, recommendations how a system may mitigate its risk. And these are what we've interpreted as kind of best practices, stuff that has been discussed at the committee meeting. Some of it has been gleaned from reports that we've read that we presented to the board at the last meeting. And so these were to give members an idea and to some discussion points about some of the items that we've been looking at in the committee meetings as moving forward with the report and what we present at the August meeting, to give members who aren't on the committee an opportunity to comment on what we've already discussed, if there's any direction that those members would like to provide the committee as we move over the summer to more study on this and drafting that report to bring back to the board in August.
Chris, I would note that between now and August, there will be some additional input coming from the American Academy of Actuaries Public Plans Subcommittee, of which I'm a member. We were talking about mitigation of risk 2 days ago in a conference call, so I may have some additional information from that source to include in our report.
Okay, good. All right, we'll move on to the next item, item 6, receive report on 39th Enrolled Actuaries Meeting. Bob?
Well, I was pleased that Dan Moore, our staff actuary, attended, and as well as I attended. I've attended it for many years, and it's the largest block of public of actuaries. Over the years, the mix of the actuaries on pension plans has changed from predominantly private sector plans to, if not more public sector plans, a seemingly equal number, and that's because private sector plans many of them have gone away, have terminated, and public sector plans are very little termination so far, a lot of change, but so the mix of actuaries, there's a lot more public sector actuaries with a higher profile than there would have been 10 or 20 years ago. I would note that at that meeting, and I was on a panel with the president of the American Academy of Actuaries, our largest organization. And since that time, I see that he's written, this is a personal opinion but it is from the president of an organization, very concerned about public plans and the actuarial work of public plans, and is saying that let's split apart public and private sector, and for the public sector plans, the employers need to contribute more. They need to contribute what the actuary is recommending that they contribute. And he's also saying that within that pressure that the actuaries need to look harder at what they're doing, and he's specifically saying that he would like to see the Actuarial Standards Board develop a position on funding. I mean, we have a position on funding through our guidelines for actuarial soundness, and that would be unprecedented if it happened. I think it's unlikely to happen because the Actuarial Standards Board is sort of like the Supreme Court. Maybe they set back at a distance and they're very slow to change. But it could be material if they did move that way, because actuaries are required to do what the Standards Board says. It's not optional. Now that didn't mean an employer has to do what the actuary recommends, but it would force some change in the actual profession. I hope it, and doubt if it will go there, but it's showing there's a real concern in the actual profession about public sector defined benefit plans, and we're trying to step up. We've got work at committee level going on in 3 different organizations. But it is going to ultimately come back to, I think, primarily an employer stepping up to pay, or if they can't pay, stepping back benefits to where they can pay them for the systems to be long-term viable. That's all I have on that item.
Okay, good. Thanks, Bob. The next item, item 7, we receive report on public retirement systems reporting and compliance, including the Form PRB 1000 investment returns and assumption report.
Members, quickly to update you, as changed last session, we are required to post a list online of systems that are not submitting within the 60-day period their reports required, their annual financial membership reports. And we're pleased to report at this point that everybody is compliant with that, and the list is before you with nobody on it. I think that's probably the first time in the history of the Pension Review Board there's nobody who hasn't sent their reports in on time. And there was one system prior, in accordance with the recommendation or the requirement that we send letters when they're non-compliant to their sponsoring entity. We are now also sending letters when they do become compliant, so they know. And Waxahachie Fire did submit their reports. They are now compliant, and we notified their sponsoring entity that they are now in compliance, so we've included a copy of that letter. And lastly, I just wanted to touch on this new Pension Review Board PRB Form 1000, the Investment Return and Assumptions Report, added by House Bill 13. It's a brand new annual report that all systems are required to submit at the same time as their financial and membership information, requiring the last 10-year individual year gross and net returns, last 10 valuation, assumed rate of return, as well as their 1, 3, 10, and 30-year gross and net rolling returns. To date, and it's based on the planned fiscal year, we've received 25 of those reports. And we've had some questions. I think for some systems this is a brand new report. We're trying, staff is really making an effort to reach out to systems to let them know, to offer assistance. We have received some comment in terms of the forms that the board has adopted, how that's helped systems submit this information, and certainly we want to continue to help those folks out there watching or in the audience. If you have questions, please let us know. But at this point we have received those reports, and by the end of the summer, and we would expect it in the study that these plans reports will be incorporated into what we put in the study. But I did want to give an update in that regard.
Good deal. Thanks, Chris, and good news. Item 8, discuss and consider strategic planning for fiscal years 2015 through 2019, including 8A, receive report on current draft of the strategic plan 2015 to 2019. 8B, discuss and consider agency action plan. And 8C, discuss and consider technology resource planning. Chris?
Members, as we enter the next budget cycle, this is kind of the first step where the agency develops its strategic plan. That plan is due on June 23rd. We're on the earlier end of the cycle. So what we've presented for the members is our current draft. This will continue to be updated. But we did want to give the members an opportunity to take a look at the current draft that we have. A lot of this is boilerplate in the sense of what the board's requirements and statutory duties are, organizational charts. I did want to kind of point out a couple key items that we wanted to bring to the board's attention for the board to consider. On page 4, the mission statement of the Pension Review Board and the philosophy of the Pension Review Board. If any of the members wanted to provide any comments or suggested changes to that, we thought obviously this was the opportunity to do it. This mission statement was adopted by the board in the late 90s. It's consistent with the directive of the board, but it is the underlying language. It's an opportunity for the board to consider any changes to that. So we did want to provide members that comment period, and certainly if there are comments that come in later, we can incorporate those in. Again, June 23rd is our deadline for submission, but we did want to make the members aware of that.
Okay, good.
And just, I guess the next 2 items under the agenda tie into elements of the strategic plan, the agency action plan and the technology resource planning. are elements of strategic planning process that we wanted to get input from the members on. Staff have held discussions internally looking at this. The agency action plans are not actually required to be in the strategic plan. You can put them in the past we have. Technology resource planning is required to be in there. But behind tab B, we've laid out for items for discussion agency action plans, and this ties into partly into our current year activities and the new changes that went into effect. So what we have, and they're based on our strategies under our performance measures. We have the financial health study, obviously, under reviews of public retirement systems, and what we've outlined is finishing up the study, moving into next session, working with policymakers through next session, and evaluating anything that needs to happen in regards to board policies or rules. And so what we try to do is outline the next couple years of work that would come out of our directive to do retirement system reviews, the study, and what we see coming forward. And so we just wanted to, we would conclude that as an action plan that we would have. We keep it obviously broad enough that it gives the board some flexibility, and again, these are suggestions for the board to consider. Under the technical assistance, impact statements, and education, we have the education initiatives through our training program. We have retirement system communication outreach. One of the items staff have begun to explore is in our technology resource planning is the use of social media platforms. Would this be advantageous for communicating in the 21st century? As we are moving online with our training, we are doing a lot of email communications to our member systems. Does it make sense to explore items such as Facebook or Twitter? Again, these aren't the determinations that we will. We're just starting to look at the options available, as well as another item that we've looked at, we'll get into in the budget request, is the idea of creating an online database system or a dashboard that we could upload all of our pension data online.
Okay, good. Any questions on that?
I've got a comment. This
Okay,
is the
Wayne.
appropriate time for it. Having been now on both ends of the state strategic planning process, I am one of the principal authors of the original plan. I think it goes back to 2000 and whatever. Actually, I think it goes back before then. And now having to assemble one of these as the head of a state agency, I want to commend the staff. This is a lot harder than you might think, getting it into the proper format, and a lot of this is pretty dry material, but it bleeds into the next topic, the budget request. And I'm extremely impressed with the ability of the staff to get this detail of a plan, though it's still a rough draft, to us for our review at this stage of the game, and just want to express my appreciation for it.
Good job.
What is the process for this? When will this be put to the public for comments?
This isn't put to the public.
This is it.
This is it.
So, okay. I think one of my main questions was about the online dashboard and uploading the information so it's in a central location. I do understand the need for that, but I'm curious as to what the audience's response would be to that.
And we put this in there for the members to consider, because under the next tab, this is a possible item the board could consider requesting funding for, to give all the members and the members of the audience a sense. First, House Bill 13 added a requirement that the Pension Review Board post all current plan data online. We have been working with the Comptroller's Office over the last couple years with the Public Pension Search Tool, where we provide the current data online, and the Comptroller's Office houses that on their website. We have a link on our website to their website. One of the discussion points, because this is now required by statute that we post this online, and some discussion with legislative staff, was whether or not it made sense for the Pension Review Board to develop its own version online, where we would upload not just necessarily current year information, but all the information on the systems on a usable format, searchable format online. We've had some discussion with our database programmer on this. We've tried to ballpark it, and we'll get to that in the budget request, but again, one of the items we wanted to bring to the board's attention for discussion is this something that would make sense? It is required that we post information online, and so that was something the staff had discussed, and we certainly want the input from the board whether or not they would like us to proceed in exploring this, continue to work with the Comptroller's Office. I will note we do have a memorandum of understanding with the Comptroller's Office to continue to do this. There is an out if the board wishes and wants to develop its own, that we just notify them. And obviously with the change in statewide leadership, we cannot speak to what the next comptroller's priorities will be. So that was part of the reason we were looking at what we could do internally. But there would be a cost associated with it and a budget request we would need to put in to accomplish what we're envisioning. So, and I think there have been some questions raised, and we haven't had a lot of feedback from the systems just yet. I know the systems are probably aware of the Comptroller's website and the information that's posted there. And there's some discussion that we've had in terms of, would we continue to just give them updates indefinitely, or would it make sense for us to try to manage that project ourselves? So just some background for the members as you discuss this item.
And maybe that's some of the discussions in connection with item 9, because you do have a specific request in the proposed request for that. But both these items need to be approved at this meeting, right?
Right. And just a very quick point, to show you how old I am, I was stumbling over the date of the first strategic plan. I think it was 1991. It was under Ann Richards' administration. And secondly, the strategic planning in this sense is an odd use of the term, because there is incredible lack of flexibility in what we can do with this. It's a very rigid structure because it does link to the state budget, so there is reason for it, but it's not quite as flexible as one might think.
So we can put it in our plan, but if they don't give us the money, we can never do it, of course.
The original vision was that the strategic plan would lay out what the agency thinks it ought to be able to do in a 6-year period. This is what we'd like to do. Then the budget request would implement the first 2 years of the agency's strategic plan. A problem that occurs is there is usually, at least again, now going back probably 20 years too, when the budget instructions go out, there will be what's called a leadership letter that instructs agencies that they cannot request any more than, and it's frequently 95% of what they had the previous biennium, thereby sort of obviating the value of the strategic plan, but it is what it is.
So Leslie, did you have any specific questions, or are you concerned about having that on it?
Well, I'm just concerned about these plans getting calls from every single person across the country, but what I heard was that it's already, and the information is already listed on the Comptroller's website, and that we've been mandated to do this anyway. So we really, okay. I don't have
And I think to the concern you're raising, obviously the contact information all systems are required to put online, or we are to put online for them, is just, it's public information. It's the address of the system and the main number. We're not looking to put executive director of a pension plan X, Y, and Z's direct line on there. We certainly would be very sensitive to that, and if we ever had something that raised that issue, we would act immediately to make sure that wasn't that information was on online. What we're looking at is the aggregate financial actuarial, the information that's on the comptroller's site.
Okay.
That the information that's public information that is required to be sent to us, and we do want to be sensitive to concerns. And certainly, if there were concerns raised by any of the systems, we would want to incorporate that into any plan that we develop going forward. We think that's a very important concern.
Okay.
Do we need today to make a decision on whether to continue to rely on the controller side or develop our own? Is that something we need to decide?
The decision of the LAR request would be if the board is amenable with us including it as one of the exceptional item requests. That's just the beginning of the process. We are going to be using the comptroller's website. The expectation is through the MOU that we would indefinitely continue using it. We're not sure, obviously, when a new comptroller comes in, maybe new staff. But even though we request it, we may not get funding for it. I mean, there's a long process ahead. This would just be, is it even worth requesting? Does the board feel that this is an appropriate project? to request funding for. The board can table this and look at it in the next budget cycle as well.
And it's more than a matter of us deciding what we want to request. It's not uncommon that when the instructions go out for the budget request that we get told to not request exceptional items or to limit exceptional items to one or two or to certain criteria. This would be providing the staff with the latitude to work within the parameters of the budget instructions to develop a request.
And our expectation in talking, I think maybe early June, some of those instructions will be coming out.
And I think we're getting a little out of order here, so maybe we ought to go ahead and finish item 8 because we're sort of jumping into item 9 without reading into the record. So unless anybody has any further discussion on item 8, I'd entertain a motion to approve the agency's submission of the strategic plan for fiscal years 2015 through 2019 pending final approval by the chair of the legislative committee and the board chair.
So moved.
Motion made by Mr. May, seconded by Mr. Roberts. All those in favor?
Aye.
Any opposed? Motion carries. Okay, so item 9 is a discussion and consider fiscal years 2015 through 2016 legislative appropriation request. And Chris, can you go ahead?
Members, and behind tab 6 is focuses specifically on the possible exceptional items for your consideration, and as noted before, there may be specific instructions about what may or may not be asked for. What we've outlined are requests evaluated based on kind of our budgetary needs on an internal discussion basis. The first item reflects a request in our fiscal note from House Bill 13, where we did receive additional funding. However, in fiscal year 2015, a portion of that general revenue request was funded through a fee mechanism through our training program for $30,000. Obviously, that training program isn't in place yet, and secondly, our council noted that you cannot pay staff salaries on a potential fee, that's against state law, and that's our interpretation from her. Essentially what it means is we had $30,000 less in fiscal year 2015 than we do in this current fiscal year. And that, for an agency of our size, is significant enough that we would like to request restoration, so to speak, in general revenue funding for each fiscal year. That funding was for staff, and that has limited our ability to be fully staffed, and so that funding is for the implementation of this training program. So that definitely is, per my recommendation, my number one request I would ask of the board to consider.
And I, at the right time, well, maybe I think we ought to make this request.
Okay, we'll go ahead and let's go through the rest.
The second item, as many folks know, the legislature approved a 1% and a 2% increase for classified salary positions for fiscal years 2014 and 2015. That money is deposited in our budget, but it's not actually part of our baseline budget. And so what we've calculated is that increase in staff salary that if it's not added to agencies' budgets in the next biennium, we would be short for staff salaries. And so that request, that amount represented here.
Okay.
I thought that money, it's appropriated to the controller, and I thought that it actually got transferred into our budget, and it shows up as expended here, so it would be in the baseline budget.
Perhaps. I'm not sure if it's going to be in the baseline. We haven't gotten the instructions yet.
Yet.
I mean, obviously, if it's in the baseline, there would be no need to ask for it. I guess our concern was if it's not in the baseline.
Okay, gotcha. If it's not, then we ought to make this request. I would hope that it is.
And if it is in the baseline, there would be no need for this request. It's just our concern, and it wasn't clear coming out of last session what the intent was, but we did want to at least make the board aware of that, and that certainly would be, for an agency of our size, we're 90% salary. That is a challenge. The next item, we did receive in the last budget cycle additional funding to offset the 1% healthcare reduction from agency budget that was used to offset ERS costs. However, we did get 2 new staff positions, and so the request we made did not cover their salaries. Additionally, the legislature passed in the budget a 0.5% assessment of your salary to fund ERS. Again, for an agency of our size, it does add up. Every dollar is important to us, so what we've put in here is a request to cover the new staff that we didn't anticipate in our last request and the 0.5% there. So that's the next item, item 3. The third is the fourth is general staff salary increases that we believe are necessary. And I'll use this moment to mention that we did lose our investment analyst, Nick Ballard, to the teacher retirement system recently. And that is an issue that we continually face as a small staff. We have excellent staff working for us. I'm very fortunate to have such great folks working with me and for the board, but we do always face the challenge of being able to pay competitive salaries and losing our great staff. It's unfortunately a part of doing business and being in the state, but I would like to get the board's blessing to consider requesting additional funding for staff salaries above and beyond the minimum that the state had provided in the last budget. And the last item is the dashboard funding. That was the estimate that we had gotten from our database programmer. This would be a one-time request, members. This is not an ongoing. This would be a singular one-time request. We would ask for unexpended balance continuation as well, where if we did not complete the projects totally in the first year of the next biennium, we could some of that money or all that money would continue over. But this would be a one-time request. It would not be in addition to our baseline, and that's the exceptional items that staff have put together and that I've put together to bring to the board's attention.
Sure.
I'd be happy to answer any questions the members may have. And again, just to let you know, we haven't received a specific date of when our LAR will be submitted. Usually the cycles break out to the end of July or early August. And I think we're going to be on the early cycle this year, so we're probably looking at mid to late July. I'm speculating there, but my expectation would be, based on history, that our LAR would be due sometime around the mid to end of July.
Any questions or comments? I know one thing we've looked at in the past, and this is more for the board than Chris, is, and maybe we need some more data before we make any requests, but our executive director position has been less compensated than perhaps comparable positions of agencies. And I don't know where we are. We're successful in getting certain additional compensation paid in the past, but we might want to take a look to see where we are and whether it's appropriate for the board to make such a request. Because we don't want to lose well-qualified people, just like we're making requests for other members of staff. I think we ought to maybe take a look at it from the executive director. I don't really have the data to say whether or not we ought to make a recommendation, but maybe if you can gather that data and provide it to me, then we can see whether that's something appropriate.
And I'm losing track of the time. Frequently, I don't know if he does it every biennium, but the state auditor does an evaluation of exempt positions. It may be out, it may not be, but that would be a potential source for it. I mean, it's something that could be modified going to the legislature, but I think it would be good for us to have some flexibility to make some kind of request in the document.
I agree. I don't think we need a lot of data to know that the executive director is justified in a higher salary.
I agree.
Okay, so that's one item we want to consider adding. Now, the first 4 items were basically salary and benefits. Now, the last item was the one we had been speaking of before, which was this online PRB data dashboard. Are people comfortable sort of keeping it in the mix unless we hear instructions contrary, or is that something? Are you?
I'm comfortable.
Okay, so we can add that. With that confirmation and that additional change with respect to the executive directory, possible salary increase, I would entertain a motion to approve the agency's submission of the legislative appropriations request pending final approval by the chair of the legislative committee and the board chair.
So moved.
I have a motion by Mr. Brainerd. Do I have a second?
Second.
Second by Mr. Roberts. All those in favor?
Aye.
Any opposed? Motion carries. Chris, can we go ahead and take everything we need action item on? We have the possibility of losing a quorum shortly. So.
Yes, members. I think the next item is actually the next item on the agenda. It's the approval of the updated fiscal year 2014 operating budget. Members, as I mentioned previously, we did lose one of our staff members. And given the amount of work we're going through, we don't expect to fill that position in the immediate future. We would hope that maybe by August we can post that position, but we've got a lot we're working on right now, and trying to bring somebody into the mix, get them trained, interviewed, all that is really not going to be feasible. So with that in mind, we do have a little bit of flexibility as we discuss items such as developing online training, delivering training content through an LMS system, and also developing this database to track the courses that are being taken in the training program so that we know what everybody's doing. So we've amended, and what you have in front of you is the proposed budget that we would hope to use to close out the fiscal year to address some of these issues. So we've shifted some funds around to try to address our software and hardware needs going forward for the next 3 months. And that budget is here for your consideration. And we would present a final budget at the August meeting. But this is to the best of our ability to anticipate our needs over the next 3 months, where we think we'll be spending the remainder of our fiscal year budget.
Any questions or discussion on the updated budget? Hearing none, I would entertain a motion to adopt the updated fiscal year 2014 operating budget as presented.
So moved.
Second.
Motion made by Mr. Roberts, second by Mr. Brainerd. All those in favor?
Aye.
Any opposed? Motion carries. And then why don't we jump to item 11, just because it looks like we might need some action on that, which discuss and consider board approval to attend the 2014 TechSpurs Summer Conference. Are the people who are planning on attending this? I know Mr. Mascale in the past has had an interest in this. Does anyone else have an interest in attending?
I have an interest.
Okay.
I have an interest, but there's no way I can do it.
When is it? And how long is it?
It's I believe it's August 10th. It's 11th. It's the second week of August, if I'm not mistaken, in Houston.
Yeah, I'd love to do
And
it.
it's a Monday meeting?
Sunday, Monday, Tuesday.
Sunday, Monday, Tuesday in August. So I believe that would be might be the 11th, 12th, and 13th of August.
I have a conflict, so thank you.
So Mr. May and let's see if Mr. Massengale has an interest. Anyone else? Okay, well, if the board is okay with that, I would entertain a motion to approve the attendance of Mr. May and possibly Mr. Massengale at the 2014 TechSpurs Summer Conference.
So moved.
Second.
Motion made by Mr. Brainerd, seconded by Ms. Greco-Poole. All those in favor?
Aye.
Any opposed? Motion carries. Okay,
Show me voting aye on that. I was not paying attention.
I show everybody voting aye on that one.
Works for me.
Well, I guess Mr. May can abstain if you want. All right, well, then we go back to 10B and do the reports. 10B is report on 2014 annual TechSpurs Conference. 10C is report on 2014 TELFRA new trustee employee. 10D is report on agency website. And 10E is report on the 83rd legislative interim hearings.
Members, just to briefly update you, I did speak at the 25th Annual TechSpurs Conference in March in Fort Worth. I believe that was well received, and we were able to provide an update on current PRB activities. We did receive a lot of questions. I appreciate TechSpurs providing the opportunity for the PRB to communicate its activities. I think our dialogue with the systems is going well. I want to continue to work with those folks. Additionally, I did provide a similar presentation last week at the TELFRA peer review training here in Austin, and very thankful for the opportunity to communicate that with the folks from TELFRA boards, the system administrators and trustees. Again, a lot of the folks out there in our pension community are doing training already, and we've been trying to work with those folks as we adopt this training program and put it in place. We have TechSpurs and TELFRA representation on our working group, and we think that's been invaluable in crafting and developing this program. Their feedback has been very important. But I did want to let the members know I am scheduled to present at the Fall 2014 TELFRA Conference as well in Lufkin, Texas, which will be in September, and I'll provide a board an update after that. But the feedback has been positive, and we believe that engaging our constituents in this way really helps communicate what the board's doing. Also make sure that we hear comments, positive and negative, concerns, issues that are raised, so that we can incorporate that and make the board aware. So that I did want to update the board on that. As well, we do have a short report on the web stats behind tab, I believe it's 7C. If the members don't have any questions, I'd like to go right into, I believe 7B is the web stats, what's behind tab 7C, because it relates to the interim hearings. I did receive more current information. My expectation, unless, again, the members have questions on the web stats, House pensions interim hearings will take place in July, on July 8th, 9th, and 10th. Some of those hearings will be in conjunction with House appropriations. You can see the House Pension Committee, there's really nothing directed specifically to the agency other than oversight and monitoring agencies under the committee's jurisdiction. I did meet with House Pension staff on April 16th, and I think I'd sent the members an update via email. I provided the report I provided them, which is basically an update on what the Pension Review Board has been doing in the interim, specifically an update on the implementation of House Bill 13 and an update on Senate Bill 200, our sunset bill. That was well received and basically was instructed that continue the good work, and we'll be updating the committee on our activities in July. Again, if you look at the interim charges, most of those focus on ERS and TRS healthcare and GASB. Certainly we'll be happy to help the committee with any questions or comments or needs they have during that time, but I believe our requirements will mostly be to update the committee on what the board is doing. But just want to let the members know, July 8th, 9th, and 10th are the 3 days they've carved out. Certainly, if any of the members want to attend, please let me know, and as I know specifically what day we will be asked to appear, I will let the members know.
I would like to try to attend.
The members don't have any other questions. That concludes my executive director's report.
Okay, so let's move to item 12. It's a call for future PRB agenda items. If anyone has specific items that you want included in future agendas, please email Chris and he'll circulate it to me prior to the meeting. Item 13, just public notice that the date and location of the next PRB meeting is currently scheduled to be Thursday, August 28th here in Austin. Item 14 is the invitation for public comment. Do we have anybody in the audience who's either signed up to want to speak on an item or signed up or want to speak about anything generally? Seeing no race to the podium, we'll move on, and I'll entertain a motion to adjourn.
So moved.
I was going to make one more comment, but it's out of order.
No, go ahead, Bob.
Well, Wayne, I wanted to follow up on the earlier question you raised about the health of the Texas plans vis-a-vis compared to the nation. I think, as I reflect on it further, I think I was somewhat too pessimistic. I am not giving enough weight to two very large Texas plans, the Texas Municipal Retirement System and the Texas County and District Retirement System. They have respectively, I don't know, 700 or 800 or 900 cities and 500 or 600 counties and districts in the state. And they're set up under a state law. The state law sets a set of trustees. Those trustees hire actuaries. The actuary determines the rate, and every county and every city makes that contribution every year. So when you have two really large cities and large systems in a large state, all funding well, I think I understated. I mean, the problems are here. I mean, I'm not saying we don't have them, but in perspective, I probably understated this some, because those two systems are doing, on a funding basis, they're doing it all. They're doing what they need to do.
Thank you.
Thanks for the clarifying remarks. So I think there's a motion to adjourn from Mr. Brainard.
Second.
All those in favor?
Aye.
Motion carries. Thank you very much.